Mr. Kendrick, you have been found not guilty on all charges. Mr. Stillwell, can you please stand? You have been found guilty on count 64, possession of a firearm by a convicted felon, and not guilty on every other charge. So, ladies and gentlemen of the jury, you are officially released from further service, and I cannot express the degree of thanks that Fulton County owes you for your service. Given the length of this trial, you have paid close attention this entire time, and I appreciate your devotion, as I'm sure do the parties in this case. You are welcome to stay for the sentencing, or you can return to the jury room. I would like to speak with you in just a moment in the jury room. If you all do want to stay, you're welcome to stay. Is there any objection to the form or the legality of this verdict? No. Any from the defense? All right. All right. Is there any reason that we can't go ahead and sentence?
Phil Holloway, former assistant district attorney, former police officer, and legal advisor to Georgia's Sheriff's Department. Phil, pick this up where Alexis was reporting. The gun is very unusual. It seems to be a modern version of of a well-rod pistol, which was developed for the British Special Operations Executive, which was Churchill's secret army. It is a bolt-action suppressed pistol, or a modern version of that, where it's designed to have a silencing effect. It's a weird gun, and it would be easy to trace if that indeed is the modern version of that very somewhat rare bolt-action pistol from the 1940s.
Yeah, Dagan, great to be with you. That well-rod gun is, in fact, very, very unusual. It was described as the perfect, like, assassin's weapon. So if, in fact, that's what the gun was, and it looks like that to me as well, it's not something that's widely sold, okay? And so that's the kind of thing that authorities, particularly like the DEA and the ATF, they can go in and check these records to see who might have been in there buying a weapon like that. But if you take it a step further, in law enforcement cases like this, you always have to start at the center and work out. So that means not only from the victim himself, look at his phone, his electronics, work outward and talk to the people that are in his life and perhaps eliminate them as potential suspects, but the alleged shooter as well, Dagan. Now that we know probably that he traveled to New York from here in Atlanta, just a couple of miles from where I'm sitting now, I can tell you that Atlanta, like New York, has a very robust crime camera system, and the Greyhound station is in an area of Midtown where there's lots of high-rise buildings, lots of corporate offices, lots of other types of businesses. All of those places also have private security. So at some point, when you go backwards in time from this assassination, and that's what it was, he probably has let his guard down. He's had an interaction. He's taken an Uber. He's bought a sandwich somewhere. He's used a credit card. He's used his own phone. And not to mention, we've got his face. Family, people know him, his friends, acquaintances, probably prior coworkers, they know him. Law enforcement, if they don't already have his name, and I think they might, they are going to have it very soon, because he's not a professional in the sense that, you know, he covered his tracks back that far.
Right, and he, according to reports, took an Uber back to the hostel the second night that he checked back in. And, of course, United Healthcare would have a giant security unit and would be able to provide any information to the NYPD and investigators about threats to the CEO in prior days, weeks, months, even years. But moving on to this.
And we are following some breaking news in the New York City subway chokehold trial. The judge has dismissed the second-degree manslaughter charge against Daniel Penny. A lesser charge of criminally negligent homicide is still being deliberated by the jury. CBS News New York anchor and reporter Alice Gaynor has more outside of the New York City courthouse. So, Alice, talk to us about what happened in court on Friday.
So this morning, the jury sent a note saying they were unable to reach a unanimous decision on count one. That's the more serious charge of manslaughter in the second degree. So the judge told them, go back, start your deliberations again, have an open mind. Well, this afternoon, they sent a second note saying they were deadlocked. They were still unable to reach a unanimous decision. The defense wanted to have a mistrial. That's what their request was. Prosecutors wanted to have a motion to dismiss that top charge, which the judge then granted. So the jury was brought back in. The judge told them, we're dismissing the top charge, so you're now going to go back and deliberate on the lesser charge, which is count two. That's criminally negligent homicide. But he sent them home for the day, so they're going to take the weekend, clear their minds, and they will begin their deliberations on the lesser charge on Monday. If convicted, that carries a punishment of up to 4 years behind bars.
All right, Alice Gaynor.
All right, welcome back Inside the Law, everyone. I'm your host, Philip Holloway. This, of course, being the LawTube channel, where we take you inside the real justice system to show you what it's like in my world. And, you know, if all you do is get your criminal justice information from the mass media or from watching the movies or other television, you're missing out on a lot. Because if you want to know what's going on in the real system, come right here Inside the Law, because that's where we're going to take you. We're going to show you what it's really like. And of course, we got a lot to talk about. I'm very, very excited about today's live stream. We got a few topics, as you probably can tell from the introductory videos. Of course, we've been covering and talking a lot about the Young Thug YSL trial that has recently concluded here in Fulton County, Georgia, which is where I am. And so, of course, we're going to have to lead with that. We're going to then, of course, get into a couple of other topics that are in the news. And by the way, before I forget, I'm not going to say, I'm going to limit the use of the M word due to algorithmic reasons. I don't want to get demonetized here, because this is a channel that, you know, it's part of my business, right? So we want to make sure it stays monetized. So we want to kind of refrain from some of that might get trapped in the algorithm. But we're also going to get into so we got this case in New York. It's the manhunt for the United Health CEO, the gentleman who was unfortunately killed on a street in New York. And there is a massive manhunt now that's going into multiple states, and it's quite the mystery. We're going to have my colleague and friend Paul Mauro joining us a little later in the show. He's going to help us break that down, along with Rachel Kaufman. And of course, we're going to talk about the Daniel Penny case, which is also something going on, not on the streets of Manhattan, at least not supposed to be anyway, but it's in a courtroom in Manhattan, and we've got some very curious goings on there as it pertains to really what ought to be a hung jury. But the jury's coming back on Monday to continue deliberations, and I don't think they're supposed to. I think that's not what the law intends, but Rachel and Paul will help us sort all that out. But without further ado, we've got to, of course, talk about the big news. YSL, as you saw, if the trial's over, there's a verdict, and it was not guilty. So let's give a big Inside the Law welcome back to our friend and our colleague, my colleague, Rachel Kaufman and Doug Weinstein. Wait a minute. Hold on a second. Let's see. Where's Doug? Rachel, I'm looking for Doug. Do you see Doug?
I do not see Doug.
Oh, well, we can't do this without Doug. Let's see now. Oh, wait a minute. I found him. Hang on a second here. Big welcome to Doug Weinstein, everybody, here Inside the Law. I had to go back in time to find him. Let's see what he has to say. Oh, hey, look who I found. There's our friend Doug. I only had to go back in time about an hour or so to find Doug. Doug, how are you, my friend? You look like a man who has the weight of the world just removed from his shoulders.
Wow, that's a good way to. That's kind of the way I feel. Of course, Mr. Kendrick Diamante, he feels even more that way. You could actually see it if you watch him in court when that verdict was read.
Well, as it just so happens, I've got that, and we played it at the beginning of the show. I'm gonna play just another minute or so of it here because look, they say a picture says that it's worth 1,000 words. This video is worth 10 million words. Just take a look.
Mr. Kendrick, you have been found not guilty on all charges.
All right, Rachel, I'm gonna pause this interview because this is weird. We're gonna incorporate this recorded video with Doug, but I wanted to have you in this conversation as well. So as you can see, and we played this right out of the gate in the introduction to the show, at this moment, right, when the judge has the verdict form in their hand, right, and you're the lawyer and your client's fate's in your hands. I don't know, Rachel, of any more intense moment in the life of a trial attorney than that one. And we're going to get Doug's comments on it here, but Rachel, I wanted to get your take on what this moment is like in general for lawyers.
I mean, they talk about glory. I mean, it's shock. First of all, leading up to the verdict, it's shocking. You're just kind of waiting. The judge sees it before you get to see it. So there is some kind of answer, but you don't know what it's going to be. Usually there's a lot more deputies surrounding them. So that kind of told me that he wasn't going, they weren't concerned about him flipping out at the verdict. And the judge just sort of blurted it out, which they usually have like the foreperson read it.
Yeah.
I was a little surprised by how it went, but all I can tell you is that, in that moment, they've been fighting for years for this. And so it's just the most glorious thing you could ever imagine.
All right. So let's carry on with what Doug had to say.
Mr. Stillwell, can you please stand? You have been found guilty on count 64, possession of a firearm by a convicted felon, and not guilty on every other charge. So, ladies and gentlemen of the jury, you are officially released from further service, and I cannot express the degree of thanks that Fulton County owes you for your service. Given the length of this trial, you have paid close attention this entire time, and I appreciate your devotion, as I'm sure do the parties in this case. You are welcome to stay for the sentencing, or you can return to the jury room. I would like to speak with you in just a moment in the jury room. If you all do want to stay, you're welcome to stay. Is there any objection to the form or the legality of this verdict? No. Any from the defense? All right.
You notice, Rachel, right there before we get to, it's almost like Doug was like, oh my gosh, there's something else. Because everything's going through your mind, right? You've just had this tremendous experience that's just indescribable. And then the judge asks you to, is there any objection to the form of it? Have you ever seen anybody object to a not guilty verdict form?
No, but I have seen them ask to poll the jury, which is basically where the judge asks each juror who deliberated whether this is in fact their true verdict, which can kind of get interesting because sometimes if there had been concerns about possible, when the judge reads the Allen charge and said you have to continue to deliberate, and it's an interesting situation. Sometimes a juror can be like, well, that really wasn't my verdict, but in this case it's
yeah, well, if it's an acquittal, if it's not guilty, there's no reason for the defense to poll the jurors. But and I've seen prosecutors do it when there's an acquittal, and that's just in really, really bad form. But that's a topic for maybe another day. But anyway, so no polling of the jurors. So here we go. Doug, I was beginning to wonder, like, if you forgot to speak when the judge asked if there was any objections to the form of the verdict. And look, I'm going to let you just take this away and tell us what it was like in that moment. But I can tell you what I saw in that video. I mean, I saw not only the bond that was forged between attorney and client over the last, I guess, several years, but I saw this just release, this, literally the weight of the world's just gone, and the relief, the excitement, the happiness, all of the emotions kind of, put in. That's what I saw. Tell me about it, buddy.
Yeah. I mean, we certainly thought that if the jury reviewed the evidence that this would be the result, but it's a different thing to think that that's probably what should happen, and then actually hearing that not guilty verdict or those not guilty verdicts come from the judge. And she said it so quickly, Ed, we weren't even fully, hadn't fully stood yet when it came out. And she had said she didn't want any outbursts or emotional whatever when she was reading the verdict. So, and I didn't know how Shannon's verdict was going to be read. So I was hesitant to react too much until I heard what came out from.
So that's an excellent point that Doug makes right there, guys. He's talking. So he's got all of his. He knows that he's a complete acquittal over there for him and his client. But there's another person sitting there, right? And another lawyer, another client, and they don't know if it's going to be the same verdict. But it's, if you're Max Sharp, that it's a good sign that what the news that Doug had just heard. But the charges are different for each person. So, you don't necessarily have to have an identical. And as we saw, it's, the verdict wasn't completely identical, but it was still really, really good because Max's client got released on time served with a little probation, or at least released from this case, I should say. But, when you've got another lawyer there, it's like you want to maybe start to celebrate and show, what you're thinking, but you don't want to be rude, right?
Yeah, I mean, Doug is also just like the kindest person in the world. And so that is something that obviously he would consider. I mean, I think like they've all talked about, they were all very bonded. I mean, not just attorney and client, but the co-defendants. I mean, they spent all this time together. And so I think Doug was invested in the outcome for Shannon as well. And just, out of respect for what could have possibly happened. So, Doug's the best.
Shannon, with respect to Shannon. So, but after that, and I don't think you played it all the way through, but there was a long, long embrace that we had there at the table. And he was, there were some tears that were shed there, certainly from Deamonte, and a warm embrace. Now, I'm not much of a touchy person. I'm not big on hugging or anything else, but
No,
I just couldn't help it at that point. It was such a tremendous feeling to get that victory, to get that not guilty that we've been working, both Deamonte and I and everyone on the team, Jay Apt and Katie Hingerty, we'd all been working for so long. And I was just thinking of all that went into that, of all the defense attorneys and all the folks back in the offices, everyone that had been working so hard to get to that point. I was overwhelmed throughout that day, and a lot of that was a blur. You said I didn't say anything when the judge mentioned the business about objecting to the form of the verdict. I honestly don't think I even heard her say it.
Yeah, no, I can tell, and it's just a minor thing. And for folks who may not be familiar, the way it works, at least around here where Doug and I practice, is the jury's out and they send notes back and forth. And every time there's a buzzer and, it's a note or is it a verdict, just your adrenaline starts flowing and you just get on edge. And then finally, when you find out there's a verdict, right, then you've got, oh my God, what are we going to do? You just don't know what to do. And then you got to wait sometimes 10, 15, 20 minutes for everybody to get back together and come into court. And so you're just on the edge of your seat, right, Doug? And so then the jury comes in. And the judge says, have you reached a verdict? And the foreperson says, yes, we have. And then they hand the verdict form from the bailiff up to the judge. And the judge looks at it. So sometimes I wonder if these bailiffs take a sneak peek, but I don't know. Maybe they do, maybe they don't. But at that point, it's just the jury. And then the judge looks at it. And so the judge knows what the verdict is. And in that moment, Doug, as a lawyer, Express what you were thinking when the judge was holding that verdict form, and you didn't know what it was going to be.
So
What was that?
just the level of anxiety and almost a chill that I could feel waiting for her to read that verdict. And you know what had been happening prior to that, for folks who don't know, is she had been holding a status conference in that courtroom for the 11 other, at the time, 11 other defendants waiting to be tried. And Max and I were in the courtroom because I think essentially Max could work, but I could not work while I was waiting on the verdict to come back. So I was kind of killing time and meeting old friends, right? Because we saw the co-defendants counsel that we hadn't seen in a year and a half or so. And, talking to them, watching how it was going. And all of a sudden, the judge, I guess, was handed a note and was told, and she said something to the effect of, well, I knew this would happen. I knew as soon as I used the same courtroom for this, we would be interrupted. And apparently we have a verdict from the jury. And so she dismissed the static. And from that point until she finally read it, as you say, was, I don't know, 10 or 15 minutes, the longest 10 or 15 minutes of my life, because they have to get Deamonte out there. They have to get Shannon out there. They have to clear the other guys out. It may have been 15 or 20 minutes since they had to get some other folks out of the room. The tension was unbelievable. I don't even have the right words to describe it.
Well, there's really, I agree. There's, I like to say that I've been there. I've been in your shoes. I've been in that moment where you've been fighting for days or weeks, but I mean, you've been fighting for years, right?
Yeah.
And so I've not ever experienced, I don't think anybody has. You had the longest trial on record in the state of Georgia, I believe it is, and maybe everywhere for all I know. But, look, I mean, this was your first ever criminal jury trial. I don't know how many people realize that, but I think that you should get credit for about 300 trials just in this one, right?
Well, I'm certainly going to give myself credit for 50, 60, 70 trials in the course of a 100-week trial.
Yes, absolutely. You well deserved, my friend. So let's move forward from that moment. Now, that was a complete not guilty on all counts. And I think that, to your point about, the judge just saying, okay, you're not guilty. Normally what the judges do, right? You don't have all these many counts that were listed on the verdict form. And I guess she just didn't want to go through them one by one. But normally you got to sit there and it says, all right, in count one, we, the jury, find the defendant, whatever as to whatever the charge is. And you go through them one at a time. But I guess she thought that would just take too much time. She may as well just go ahead and let you off the hook and say, okay, you're good to go, not guilty.
I guess so. I mean, she killed some opportunity for some dramatic moments there by doing that. And it kind of, it was just so quick. I wasn't expecting it to be, okay, you guys not guilty on everything. So it was honestly a bit of a stunned reaction too, in the sense that I didn't expect it to be such a very quick wave of the hand dismissal. Now let's move on to Mr. Stillwell. The whole thing was a little bit shocking, the way it was done.
And I know that, it takes some time to process it too. Like after the moment's over, but your client, of course, was in custody, and had to go back into the Fulton County Jail. So legally, it's been reported there's some other matters that came up. And in fact, by the way, before I get into that, it's worth noting that, remember, the last time you and I talked here inside the law, you had to step out for just a minute because you were getting some phone calls. Apparently, your client had been stabbed in the Fulton County Jail the day before this verdict, right?
It had actually, when I was on with you almost exactly a week ago, and I did have to step out because Tasha, his mom, kept calling over and over. And I guess she eventually sent a text that said, "We must talk now. You gotta pick up." Yeah. So that was because she had just found out that he had been stabbed in the Fulton County Jail. Now, not in Rice Street. He was staying in the South Fulton, I don't know what they call it, annex, but down in Union City. It's a much smaller jail where they moved him a few weeks ago. So he'd been staying down there. So when I'm hopping in and out of our I don't call, that it's because I was dealing with that and trying to get some answers and think eventually I just had to leave and try to work on that some more.
Yeah,
It's a
well,
very
thank
stressful
goodness.
situation.
No doubt. And thank goodness that he wasn't seriously injured. But he had to go, of course, from that courtroom. He was not released from custody because he had some other legal matters. I understand that he's either close to or maybe has pretty much helped wrap all those other matters up. Is that the case?
I don't think they're. I, I don't think they're close to wrapped up. I thought that we were getting close to wrapping it up, and Kayla Bumpus is handling all of those for
Okay.
him. So I know that she's been in negotiations to try to get those things resolved, or at least get them bonded out while they get resolved. So I spoke to her last Friday night about it. So I still expect him to be out. I would hope him to be out by Christmas so he can
Yeah.
spend Christmas with his family.
Well, maybe
Um,
so. Maybe
yeah,
so. There's still
yeah.
time.
I hope
Uh,
so. I hope so.
so you mentioned this status conference. There's how many other people remaining on this indictment now need to have their
Well,
cases disposed?
there were 11, and one of them, Jimmy Winfrey, he pled out.
Yeah.
And then I want to say that the day after he pled out, or 2 days later, the state dismissed all counts against, I think, 5 others. So I believe there are only 5 now remaining to be tried in this case. And the judge has announced that, I guess, that trial is specially set in February, and it is going to be 90 days start to finish, including jury selection.
That's what they say, but the best laid plans, especially in
Well,
lawyer talk.
I think if Judge Whitaker says 90 days, it's going to be 90 days. The other thing is, if people were
I'm
watching,
not so sure about that.
after the verdicts were all taken care of, and she brought the 11 defendants back in the room, she made a statement from the bench. I don't know if you've played that or planning on it, but she made a statement that said, well, given this verdict, I imagine the state is going to want to think through things and
Mhm.
reconsider.
I want to just say this before I pick back up with Doug. Look, when lawyers say it might take 3 hours, you need to probably double that, if not triple it. I am not convinced, Rachel, that they can do this in 90 days. They had better do it in 90 days or less, but I'm not convinced that they're capable of it. Your quick comment before we resume with Doug.
I mean, given how the Fulton County DA's office has operated thus far, they keep the brakes on as long as they possibly can. So, if they want to avoid Judge Whitaker yelling at them and kind of berating them, they're going to have to keep it moving. So,
All right.
And your plea offers I don't know, I'm not privy to anything, and I can't direct the state what to do, but some of your plea offers may change, and so maybe we should reconvene status conference for another time.
Well, she's sending Willis and company a very strong hint. Whether or not they heed that hint remains to be seen. I think that you're right. That I think that we might see some plea deals. If they're smart, they'll make some better plea deals. Are any of those remaining defendants, are they still all in jail, or are some of them out? Or do you know?
I do not know. I do not know which of the remaining ones who is in jail and who is out. Not exactly sure.
Suffice it to say that your verdict in this case sent a message really to prosecutors everywhere in the United States, Doug. I mean, to me, one of the main messages needs to be get to the point, keep your case clean, keep it concise, keep it bite-sized. And by that, I mean, don't create an indictment that is so big and so large that the court system can't easily digest it. And because you'll pay for it. If you're the prosecutor, you'll pay for it with the jury. They're not going to like you for it. It's going to, the more complicated it is, the more things that can go wrong. And when something goes wrong, when you're a prosecutor, that means reasonable doubt. And that's exactly what happened. We've heard from the foreman in this jury. And that's, he was one of the ones that was expressing that he was, he was no longer unbiased towards the end of the trial. And that was because of the state taking so long.
Yeah. I mean, excuse me. And the judge did explain to the prosecution, look, he was unbiased when he started. If he's developed certain feelings toward the prosecution, that's because of the way you guys tried the case.
Yeah.
And you talk about this sprawling case. I asked the jurors, could you remember stuff that happened last February and March and January? And they're like, well, not really. I said, and then I looked over, they had about a 2-foot set of notebooks that they had accumulated over this. I said, well, were your notes helpful? And they said, well, not particularly helpful to go back that far. So it's just, you can't try a case and expect a jury to keep everything. And then the other thing the jurors said was, I mean, they didn't understand, and they were not particularly happy at spending 3 and 4 weeks on issues that didn't relate to any of the defendants in the room, like the business with the car that fled law enforcement and slammed into the side of a dry cleaner. Why are we spending 3 or 4 weeks on that? And they kind of led the trial off with that.
Yeah.
So you've immediately got the juror going, what's going on here?
I don't know that people, you make a good point. I don't know that the folks maybe here who are, watching and following this channel because they want to learn about the real justice system. A lot of people don't know that oftentimes, if the jurors are willing to permit it, you can go back and speak to them, sometimes even in the jury room before they leave, and get feedback. And you alluded to that. Is that what you were talking about?
Yeah, that's exactly what we did. I specifically requested with the staff attorney that I'd like to speak to the jurors. So I believe it was about a half a dozen jurors, about half of them, maybe 7, stayed behind in the jury room. I went back there. Max went back there. Mr. Kokomo, members of the prosecution team. Not Adrian Love, but the other members of the prosecution team went back there, and the judge went back there. And we just asked questions of the jurors. We answered questions that the jurors had, and it was quite interesting and enlightening.
Yeah.
And I didn't ask all the questions that I wanted to ask because, honestly, I know the state had 11 other people to try, and I didn't want to help them in their trial of those 11 other people, right?
Well, that's what I was about to get at. I know this is your first time doing this with a criminal trial jury. I've done it, I don't know, countless times. Even when I lose, I talk to them. And so, because you want to know what you did right, what you did wrong, what might be able to help next time, and that sort of thing. And so I've never had the experience that you just shared where I'm back there with the prosecutor. I mean, occasionally there's some overlap, and a lot of times the judges go back, but by the time that we get to talk to them, the judge is already long gone. So I'm a little bit surprised to hear that you had this sort of informal debrief with everybody there.
We did. It was quite interesting. And the judge really didn't have much to say. I think she was more taking it all in. But the prosecution team was very, Miss Hilton pretty much led the discussion back there from the prosecution side. And again, very professional, very friendly, as you can expect Miss Hilton to be. So it was a good conversation, I think. And I think the prosecution learned some things, and we certainly learned some things. Now, whether the prosecution takes what they learned to heart is another issue.
And I know we learned some things here inside the law. And I want to just take a minute just to personally say thank you to you, Doug, so much for being willing to share so much of your time with us and bring us kind of inside the courtroom for an insider's look. And that speaks volumes to, your character, your gentlemanliness, your lawyerliness, your professionalism. And I just want to say thank you because you really have allowed us to learn I don't want to say there's nothing secret, but you brought us sort of behind the curtain a little bit to give us sort of an insider's look. And we really, really appreciate it. I know I speak for everyone.
Well, you are very welcome. And I really have to thank you. And one of the reasons I always like to come on your show is that you do a great job of educating the public. And as I've said many times, my favorite role of any role I play is as a teacher and an educator. So if I have the opportunity to come on and assist with that, it just, I love it. It brings me joy. And so, yeah, you pull back the curtain, you show people what happens. As you say, it's not a secret, but you don't always know what's going through people's heads. You don't see everything that's going on. And of course, I can't describe everything, but to the degree I can, I like to give people some insight. And I'm sure when the transcripts come out eventually, the bench conferences are going to be interesting to read. It's going to be interesting.
I was wondering if the court reporters might be off the hook and having to actually transcribe these things. So, I guess not.
Yeah.
I guess there needs to be a transcript for some purpose. But hey, look, there's no appeal for Doug Weinstein. No appeal.
No appeal. Yeah.
All right, my man, my
that's
brother.
great. That's where we wanted to get.
I know you've got your time is short and you've got to go. And I just want to ask everyone to please, big inside the law round of applause, big hand for our buddy, our friend Doug Weinstein. And Doug, now that this case is over, there's going to be other things that are in the news, and I hope you'll be willing to come back and give us your insight on things in the future, buddy.
Always, always. It would be my pleasure to come on here and talk about any area of the law that you might think that I could shed some light on. So I'll be there for you, Phil.
All right, Doug Weinstein, everybody. Hey, look, take some time off. Enjoy the holiday season, my friend. We'll talk to you later.
Looks like I'm going to be in trial in about a week, so we'll see about that.
Well, good luck.
Seriously.
See you,
Okay,
soon,
guys.
buddy.
See you, Phil.
All right, Rachel. Before we move on to our next topic, I want to give you what's your final sort of a parting thought on the YSL trial and all the things that Doug talked about. The floor is yours, Rachel. Take it away.
No, I mean, I think this was a long time coming. It's good to see the justice system work. Having seen juries do unpredictable things, I obviously was concerned and scared that the jury wouldn't get it right. They usually do get it right. I'm so glad they got it right. And I'm hoping that it will affect the DA's office and their strategies going forward with prosecution. Again, I'm not optimistic. I'm not particularly optimistic that it will affect how they handle things going forward, since they seem to think that, they spin everything to be a win for them, even though it really wasn't. And it was really a loss for Fulton County jurors, Fulton County taxpayers. So it was a loss for them, and I hope that they learn from it. That's all I can really hope. And I'm just really grateful for Judge Whitaker. It's another thing I want to say is, I was also very I tentatively hoped that she would be a good, better judge than Glanville for this. And she really demonstrated that she can be, and that she was in control, and that she let them, a judge can be a really influential participant in the courtroom, like if they're, and so I really was glad that she kind of let the state know throughout this, just that she was not impressed by their presentation of the case. And she didn't schedule it for a sentencing hearing for Shannon. She just giving people probation on these crazy counts. And she's a former prosecutor, so she saw through the BS as well. So those are my parting thoughts.
Well,
yes.
Look, we have YSL 2.0. We got the next iteration of this trial, as you heard Doug say, coming up here in a couple of months. And so, hey, we'll see if they can do better with the taxpayer dollars next time around. But hey, here inside the law, we're going to switch gears right now to our next topic. Of course, for those of you who are watching the news, you know that just a few days ago on the streets of Manhattan, the CEO of United Healthcare was killed, and the investigation is very intriguing. And there's actually a manhunt, and the manhunt has in fact moved south. Take a look at this video, and we'll be back on the other side.
Police in New York City believe the suspect they're looking for took a bus to the city that originated in Atlanta. The NYPD is now working with police in Atlanta in connection with the manhunt. Madison Scarpino is live with more. Hi, Madison.
Hi, Mike. The manhunt for the health insurance CEO is now nationwide, and authorities have their eye on the Atlanta area. The FBI is now involved. There's a $50,000 reward from them for anyone who has information that leads to an arrest. But police in New York tell Fox that there's no evidence confirming that the suspect is in Atlanta or that he ever was, but there is a chance, since police say the suspected killer rode on a Greyhound bus to New York that originated in Atlanta Atlanta, as we've been reporting, and they believe he fled New York on a bus. The Atlanta Police Department confirms that they are assisting the NYPD as needed, but Atlanta police aren't answering any questions about this investigation.
We've got the resources of the FBI here in Atlanta. And of course, there's lots of local independent law enforcement agencies that work very well with this FBI here in Atlanta. So undoubtedly, they are finding these breadcrumbs that this killer has left.
That's Phil Holloway, an Atlanta-based attorney and former police officer. He says investigators are likely honing in on the suspect's last known location and tracking every move they can.
He's got his picture on probably every security camera that he's passed by since he got off that Greyhound bus. He probably has bought a sandwich somewhere. He's interacted with people. And the big thing is, if he's from the Atlanta area, somebody knows him. I'm very confident that they will identify him very, very soon, and we'll have someone in custody.
And Holloway says that if the suspect is caught, he's facing a murder charge, but also potentially federal charges if he did, in fact, cross state lines after the murder. Back to you, Mike.
We will follow it all. Madison Scarpino live in Atlanta. Madison, thanks very much.
All right, I want to welcome to the show. Welcome back inside the law, my friend, retired NYPD Inspector and attorney extraordinaire, Paul Mauro. Paul, you're there in New York. How are things today, my friend?
All good, all good. Who is that handsome field reporter out there with the gray hair? Who's this Holloway guy?
But in the sunshine, the gray hair really, but look, Paul is, he's being a little too modest, because Paul himself actually gets out in the field from time to time, and he's actually retraced the events here. Let's take a look.
This is sort of a chilling moment. This is the actual crime scene. And this is where, walking eastbound, Mr. Thompson was walking that morning at about 6:45 a.m. when the shooter crosses the street from behind me, where we showed where he was posted up, crosses south to the south side of 54th Street underneath this awning. He then follows Mr. Thompson this way in conditions much like this, dark, but again, he knew it was Thompson. And he shoots him about here.
All right, so there's more to that video, and you guys can all go find it online. I needed to stop it before they showed the video of the actual incident for reasons that we've discussed here earlier. We don't want to be demonetized or age restricted, but you all been watching the news. You saw what happened, and Paul, that was a really good demonstration there, that walkthrough. I'll just ask you to go ahead and bring us up to speed on the latest. My video with Madison that I showed was just from today, as a matter of fact. It's when that aired. And it does look like potentially the investigation is multi-state, but there's also some new evidence that was found. Tell us about that backpack.
Right. So the police department is reporting that they found what they believe is his backpack. It's not 100%. It seems to be about 90, 95. They haven't got DNA results back, etc. The gun obviously was not in the backpack, which would have been the big hope. I thought if they did find the backpack, and they must have known he didn't leave the park with the backpack, because they have him entering the south side of the park, which is 57th Street, 58th Street, that area. He goes through the park, and then he comes out of the park, and there's two different bits of reporting. It's either in the low 80s or the high 70s on the west side of the park without the backpack, and apparently with the bike. He then loses the bike and gets in a cab. And I think that's how they track him subsequent to that, because they get the cab number. So they know, okay, the backpack's in the park someplace. People don't realize how big Central Park is. It's tremendous.
Yeah, it's really big.
Really big. So, and there's a lot of heavily nested areas, very, very dense. So you got a lot of cops out there, people scraping the park. They find a backpack. Now, people leave detritus of all type in that park. There's homeless people who more or less live in the park. Not that many, but they do. It does happen. So they're pretty sure it's his. And so far, all they've reported that was in the backpack, no manifesto, no gun, etc. But what could be a little bit of a commentary and maybe a little bit of, a snide joke is Monopoly money.
Yeah.
And
Well, I was going to ask. Yeah, I was
so
going to get into. I was going to talk about that, Rachel. I want to, and we'll go around the horn here. But we don't know what, in monopoly money terms, we don't know what the dollar amount was. But um, Rachel, do you have a theory on what that could possibly mean? Because look, it's not irrelevant. It doesn't make sense that it just happenstance that there was monopoly money in there, right? It's got to mean something. Rachel, you've look, as lawyers, we investigate cases ourselves. We review police investigations to see if they get it right. So if you're looking at this case, Rachel, what do you think? What would be your theory as to what that money might mean?
I mean, I think it's kind of similar to what we have heard was on the bullets that were left there. The defend, depose, deny. I think that clearly whoever did this was somebody who thought a lot about what they were doing. We handle a lot of cases where the motive is more obvious and there's less planning, so you don't have the opportunity to kind of be as snide and kind of almost playful in kind of a sick, like Law and Order actual TV show kind of way. Usually
Yeah.
it just happens, people kill each other, and it's not that complicated. This is a situation where someone clearly wanted to be kind of like a smartass. I mean, this is somebody who clearly has some messages that they're trying to send about how they feel about the healthcare industry, about insurance, and almost like the Joker from Batman. I mean, there's some kind of like sick, like, ha ha, I'm in control. And clearly that they expected the police to find the bag. And so they wanted the police to kind of get the message like, no, the gun's not in here, just some monopoly money, keep looking. If it wasn't real, it'd be kind of a fun TV show to watch, but
Yeah.
it's kind of sick that this is actually happening. And hi, Paul. Nice to meet you.
and you, Rachel, nice to meet you.
Well, Paul, you spent a long time working the streets of New York and Manhattan as a law enforcement officer with the NYPD, and you've worked homicide cases. Let's put on your homicide investigator hat for a minute, and you are in charge of this, and you've got this backpack full of money. Well, it's monopoly money, right? And so, what's your take on what that could possibly mean?
Well, I would agree with Rachel. If indeed this is that's very clearly a statement regarding the idea, I guess, that United Healthcare is some sort of a monopoly. Seems to go to the idea, if it is not a false flag, if he's not trying to throw everybody off the scent of some other motive, but is, taking it as it seems, it would seem to imply that he feels like somehow or other United Healthcare is a monopoly, or the insurance companies have a monopoly on healthcare in this nation, or something like that. And that argues then that his gripe is one of two things: either ideological, or he was somehow or other burned, right? Somebody in his family was denied coverage. Maybe he was denied coverage, whatever it is, but you certainly would have to start to look at that sort of a gripe.
My first theory, and I have now circled back to and by the way, my friend Mark Gruber from you probably know him from other YouTube channels. Mark said he thinks that it's because the monopoly power of this company, and of course they were in fact sued, I believe, by the Department of Justice not too
Sure.
long ago under the antitrust laws, which has to do with breaking up businesses when they get too much monopoly power or they exercise it in some illegal way. I'm not an expert on antitrust, but I do know generally it's what it's about. So I think that you guys are right. I think that's probably what it means. It's probably a reference to their monopoly power. But at first I thought, well, maybe this is somebody who themselves or maybe a loved one had a big claim denied, and this represented the dollar value of that claim. But to me, I think what makes better sense. And by the way, for those of you in the chat room and who are going to watch this later, I'm interested to see what your theories are. So post them in the chat, post them in the comments to this video, because I like to go and see what you guys are thinking about as well. But I think it's just a way of maybe giving the finger to the cops a little bit, saying this is a monopoly, and catch me if you can. Right. Speaking of catch me if you can, the reporting is that he's come. If it is a he, there's some people that think these pictures are of a female. And while we're here, at the risk of covering up some of our faces, I can just show some of these pictures that have been released here. So there you have one that shows, I guess that's I believe that one might be at the hostel where he was staying. Another one from the hostel. Now that one looks like it might have some more feminine features. I just honestly can't say for sure. But of course they had this one, guys, that came out. This is sort of new. This is recent. This is in the back of a cab, Paul. And I think they said this was, you may be, correct me if I'm wrong, I think this is they said was after the shooting.
Correct.
But in any event, that would be in some kind of a cab. So in addition to that electric bike, we've got him wearing not the same kind of a mask either. This is like the medical mask from leftover from COVID days. What do you think? I mean, he's on a bike, he's in a cab, he's all over the place. And then
he is. He seems to. The cabs were a mistake, though. Because you're going to get him going into a cab. All the cabs are numbered in the city, so that's how you got that shot. So they're tracking him by video, pulling video from which is real grunt work, but they're scraping video from all along what would be his route, and then they see him get in the cab. Now you have the number. All that stuff is trackable, and all the cabs now have video. That goes back about 15, 20 years when I was still on the street. There were a series of cab robberies and then murders. And so it was a big initiative. All the cabs are now wired for video. So that's how they got those shots. And it's also how they got a lot of his movement.
So, yeah, there's a lot more video that's out there that we don't have. Rachel, speaking of video, you're in the Atlanta area. Are you familiar with the area of town in the Midtown area where the Greyhound bus station is here in Atlanta?
I am.
Yeah. So talk to us about what type of video evidence there might be if law enforcement sort of, to Paul's word, sort of scours and scrapes the all of this stuff. What kind of security cameras or whatever might there be that might have captured this person coming or going from the Atlanta Greyhound station?
Yeah, I mean, I think that we're going to get similar type pictures. It's a very well surveilled area. I think what's interesting about this suspect is that he keeps changing his jackets, his book bags. And so, in that one picture we just saw from the cab, he's wearing like a black puffer jacket. We know that in the one when he was at the hostel, he's got kind of like an army green jacket that has like pockets on the front. And then in the video of the actual incident, he's wearing and then there's like a hoodie that he's wearing. And then in the actual video of the incident, he's wearing a different outfit. And so I think he's, clever to that extent. I think it's going to be difficult to figure out surveillance wise in Atlanta, especially on the way in. I know they said that he came from Atlanta, is my understanding. But if he came back here, they're going to be able to probably have better footage of that, since they kind of know when he's going to be here. I don't know if they know when he left Atlanta. And also for the purposes of trying to find him, it's more important to know when he came back here and then to try to trace his steps from there, I would imagine.
Paul, what would be by the way, you did for Fox, you did what any good officer would do, is actually go back and try to retrace the steps. Even as lawyers, we do that when we handle cases. We go out to the scene and put ourselves in it, because you can visualize it there in the actual environment. It helps a lot from an investigative perspective. But as putting your investigator hat back on here, what do you think is happening? Let's just say here let's say there is some movement to the south in the Atlanta area. What type of things, investigative steps might they, and by they I mean the FBI, we know, is on this, and NYPD has some. It's been confirmed that they had or maybe still do have some officers in the Atlanta area. What are the investigative steps they're taking?
Yeah, so they're going to be working with Atlanta PD, NYPD, and when I was in a unit that dealt with people all over the world, other agencies, and you always partner with somebody in the area that you're working. They're almost certainly lashed up not only with the FBI but with Atlanta PD, and everybody's making sure everything is being done legally, etc. Now, they're going exactly where Rachel said. They're going to be pulling video from in and around the Greyhound station. They're going to be seeing if anybody that is in that area remembers him doing what you said, which is coming in and buying coffee. He left the city immediately after the shooting. All right, he arrived in the city 10 days before. Not totally certain from the bus originated in Atlanta, but he could have boarded any place along that route because it stops a bunch of places. But the fact that he returned to Atlanta feels like he came from Atlanta, but
Yeah.
we don't know that for sure. Anyway, he gets back to Atlanta. They seem unequivocal about that. They're not like caveating it by saying, but he could have got off anywhere along the way after the event. They're saying he went to Atlanta. And, they're being pretty hard on that. So they're going to be doing all the stuff that we've already been talking about. And what they're really going to be hoping for here as they push out the photos is that somebody locally is going to say, I know that guy. He lives around the block. The problem here, and we had this in the marathon bombing in Boston, the Boston Marathon bombing with the Tsarnaev brothers. People forget, there was about a week, it was like 5 days, where we had photos of them that they were not identified. And in fact, we got reporting into PD that I had a couple of people up there. I sent them up. We used to work with Boston PD on various things all the time. They went right up. The reporting at the time, which did come out, was that when they kidnapped one of the guys, a guy that they kidnapped who later jumped out of the car, when they interviewed the guy that got kidnapped, he said they were speaking in a language I didn't understand, but I understood two words: bomb and New York. We got that information subsequent to the Boston Marathon bombings, so you can imagine our interest. So we were doing everything we could to throw a gauntlet around various areas in the city, et cetera. Had a lot of sort of clandestine assets. PD had a lot of very visible assets. The point is this: when the decision was made to publicize the images, we thought we'd get very quick hits, and we didn't. And when we found out later, what we found out later was that a lot of people saw Dzhokhar, the younger one, and they said to themselves, that really looks like Dzhokhar Tsarnaev, but I know him. He would never do something like this. I don't want to be accused of falsely accusing. That's a terrible thing. I don't want to put that guy into this. I'm not going to say anything. People were very, very reticent and they never did come forward. And ultimately, they found him in the boat, as we all know the story, how it ended. So there could be some of that here. He could also be something somewhat transient. It could be one of these things where, Atlanta has that has a Antifa type and Antifa adjacent people who are active down there. You had that big protest against Cop City and all of that.
Yep.
He could be transient. He could have been living it, and they're never going to give it up if they know him. So,
no, and I'm going to get to some of the Antifa types. I'm glad you mentioned that because I've got a video I want to show in just a minute. Tammy points out in the chat, caught my eye, about the bus manifest. Yeah, they can do that, but if somebody's I think you can travel on a Greyhound bus probably with an alias and maybe a fake ID of some kind. It's not like TSA. So and also buses stop at different places, but my intuition tells me that there's going to be a strong Atlanta area connection to this case. But I also think that I suspect, and please, I want to hear what you guys think, but I suspect that they know who this is. And I think they're sitting on it because they're trying to figure out who, if anyone else, was involved in this. And let me explain what I mean by that. Paul, somebody had to, somehow this person had to know when his victim was leaving at 6:45 or 50 in the morning. And it was like, it's just too convenient. And the bike, I don't think he had the bike with him on the way, right, Paul? So didn't he have to stage that bike there?
This is a conundrum. I've actually evolved on this point. So the police department timeline has him leaving by bike from way up on the Upper West Side to come to the shooting location. He gets there about an hour ahead of time. He's in the area. He goes to Starbucks, etc. But you're 100% right. He posts up right at the shooting location across the street, like 5 minutes before. That's direct from the chief of detectives. In pretty bad conditions, pretty dark conditions, darker than twilight even. He acquires Mr. Thompson coming down the street from 60, 75 feet away, knows immediately it's him and immediately moves. Now, the convention's public schedule was for 8 o'clock. So you're 100% right. How did he know he was there? And how did he know he would be there at that time? The photos of him coming out of the subway nearby where he does not have the bike, that was the real sort of contradiction in the timeline. I've come around to the idea that that's not him. I think that's a false flag, a red herring, whatever you want to call it. Red herring. That's not him. People take their bikes on the subway in New York all the time. But if it's not him coming out of the subway, then the timeline gets a little simpler. He rides the bike in from the Upper West Side. He's in the area an hour before. He surveils, makes sure there's no impediment, some strange thing. The cops aren't posted up there for some reason or something. He goes to the Starbucks. He's in the neighborhood for about an hour. 5 minutes before the hit, he's posted up in the catbird seat. And then he seems to know Thompson's coming. And remember something else, just to add to the theory that I could see it teasing out. There's that still photo of him before the hit on the phone.
Mm-hmm.
So is somebody surveilling Mr. Thompson as he leaves the nearby hotel? Did somebody give him the heads up? I asked one of the Fox reporters, who's Alexis McAdams, who's been great on this. She got an interview direct with the chief of detectives and the police commissioner. She very pointedly asked that question. Are you looking for somebody else? Chief of detectives said not at this time. But we all know you can be very, very cautious in these statements. And so I think you have to admit that possibility is still in play.
Well, Rachel, to me, if you know the name, and I think they do probably, it's just my instincts tell me that, and you might want to hold on to it for investigative reasons so that you don't alert any other third persons that you might also be investigating, because if this person had any help before, during, or even after, then that person is guilty of a crime or crimes as well. And so you would want to make sure you build an airtight case around anybody else. Rachel, what do you think? You think there's possibly other people involved in this?
Yeah, I mean, this seems like a motive, though personal, kind of seems more like an act of, in their opinion, of like morality and heroism. I think the Antifa, I think you're onto something. I think that I don't believe that he acted alone, and I think that part of the reason, I don't know whether they have his name or not, but I imagine that although it is a lot of work to try to chase down every lead that they're getting, I think they want the calls to continue to come in. I think they want to hear from anybody who thinks that they know anything about how this happened, not just who fired the shot. I think Paul bringing up the Boston Marathon thing was really interesting. And what makes this case, I think, even harder to solve is that if you've looked on Instagram, TikTok, the reaction of the far left specifically to what happened and to this guy's death. I feel like there's a lot of people justifying it, making jokes of it, and feeling like, feeling like it was somehow justified. And so you have the people that the shooter may be involved with. I mean, they're not going to come forward in ways that I think the people that knew the Boston bombers would maybe have come forward, because what they did was so much less targeted towards an individual who they could justify doing that to. So
this person has some fans, probably some in take a look at this video.
Wait, that's even better. Sorry. There's a musician. There's supposed to be.
I just wear a green.
Steal his look.
I just have a green jacket.
I think I lost him.
Are you guys worried in participating in the lookalike contest during the search?
No, because we're shiesties. I'm not worried because I'm not a CEO. So yeah. I feel pretty safe. Like, if I was a CEO, I would be worried, to tell you the truth. But given that I'm not, and I'm just your average working class man, I don't really have much to fear. There's like city bikes around here. Like I can just yeah, a little something like that.
All right, so it's a look-alike contest. They're in Manhattan, and there's some really disturbing other content. We won't get into all of that you can find, like Rachel mentioned, on TikTok and other places, anywhere really, even any social media platform. You can find sentiment that it would suggest that there's a large, maybe a vocal minority of people that would not be in a hurry, Paul, to want to help the police if they sat by him on the bus or if they knew him from work or something like that.
Right. This is one of those cases, you get them every now and then, where you're turning over a rock and finding something that you didn't know was there. Where, from my former role, etc., very conversant with some of the really extreme groups. And you see the tip of the iceberg a little bit in some of these campus protests, which are heavily anti-Semitic, anti-Israel, etc. And they segue undeniably into blatant anti-Semitism. But the thing here is that I did not realize that there was this enormous anti-insurance movement. But apparently out in Minnesota, where this guy was from, there were ongoing protests relative to United Healthcare. And this seems to have struck a chord that was there that I personally was not aware of. So, yeah, they are all going to be far left or far left adjacent. As I say, people that are very much in sympathy with the cause. And those are not people who are going to give it up. And in fact, they very well may abet him staying out of the hands of the police. And the other disturbing thing about this is that sentiment and those connections are very international. You see it in the campus stuff. The money's coming in from Iran. They have people coming in. When they did some of the arrests that they did up at Columbia, there were people from all over the world in the net. So you got to hope that this guy is not already running around someplace in Europe.
Well, look, look. The investigation will continue, and we're going to continue to keep an eye on it. I want to go ahead and switch gears, though, to another case that's high profile, been all in the media, and this is, of course, the Daniel Penny trial. I'll just set the stage here, then we'll dive into it. On Friday, the jury sent word that it was hopelessly deadlocked as to count one, which was a manslaughter charge based on the idea basically of recklessness, being, someone recklessly disregarding the risk that whatever they're doing is going to cause serious bodily injury or death to someone. And so the jury was deadlocked on that. And there was a kerfuffle over what to do next, because the way it works in New York, Paul, correct me if I'm wrong, at least in this, the jury had count two, which is what we call a lesser included offense. It's something that's usually not as serious. It doesn't involve the same elements, but it would be lesser and it would be included within the same broader umbrella of the case, which would be encapsulated by the top count one. And so normally in New York, the jury cannot get to consider the question of guilt or innocence on count two unless there is a verdict of not guilty in count one. Did I get that more or less correct?
You did. And in fact, the judge stated precisely that in court.
So I put this is now the pinned tweet or post on my X account. If anybody wants to see it, go to my X account. And let me just, this is the exact jury charge. Now I want you two lawyers to help us break this down, but I'll read it out. It says, if you find the defendant guilty of count one, manslaughter in the second degree, then do not consider or even render a verdict on count two, which is criminally negligent homicide. However, it goes on to say, if you find the defendant not guilty of count one, manslaughter in the second degree, for the reason that the people, that is the state, has failed to prove beyond a reasonable doubt that the defendant was not justified. Remember, they're saying this is justified, it was self-defense. It says, then you must not consider count two. criminally negligent homicide, and you must also find the defendant not guilty of that count. And then at the last part of this, it says, if you find the defendant not guilty of count 1, manslaughter in the second degree, for some reason other than justification or the lack thereof, then proceed to consider and render a verdict on count 2, which is criminally negligent homicide. So they didn't meet the conditions. This is what, after the lawyers, guys, after they do their closing arguments, they talk to the jury, about the judge's instructions, and then they make their legal arguments knowing what the judge is going to instruct. So they make their legal arguments according to this jury instruction. And so they didn't argue it any other way. And so the conditions that were set out in these instructions, there were conditions that must be met before the jury could get to count 2. They weren't met. It was a hung jury. And my reading of this is that should have been the end of it. It should have been a mistrial altogether. But they're coming back Monday. Can either one of you, and Rachel, you can go first, can you guys help me understand how the jury is now getting to deliberate on count 2? Because let me actually add this big piece of it. The prosecutor made the move, and I think this was a cheap, under the table, below the belt move. They said, we'll just go ahead and dismiss count 1 so that all that is left is count 2. All right. And it was dismissed, by the way, over the objection of the defense. I mean, I think it's gone forever because of double jeopardy now, but they did that because they know that there's a lesser degree of proof, I guess, at least in terms of it just requires proof of criminal negligence instead of recklessness. And so they think it's probably an easier sell to the jury, and they can still sentence him to up to 4 years. Anyway, Rachel, can you make sense of that?
No, and I don't think I've ever seen anything like that happen before. I'm wondering if because the judge dismissed count 1 without having had any interaction with the jurors regarding whether it was based on a lack of justification or based on justification, I guess the thing to let them do would be to go forward on. It's not my dog. Hello, sweetheart. I know my dogs are always really bad.
That was my reaction too, actually, to the judge's decision.
Yeah, I mean, I think that's very interesting to me. But what would it mean for criminally negligent homicide for the issue to not be based on justification would be, I guess, how he died would be the only, whether the fentanyl, because my understanding is that during the hearing or during the trial, the medical examiner didn't even want to consider the fact that some of the things that he had in his toxicology report affected how he died. And so possibly that could be the basis for, I guess, not finding him guilty of a criminally negligent homicide. Either way, the whole, once you're getting to criminally negligent homicide, are we really talking about criminal intent anymore? Or are we just like trying to punish somebody because of what?
Yeah, by definition, you're not talking about intent.
No, well, then at that point, I'm over it. Sorry. I mean, I hate that the guy died. I feel bad that he lost his life. Yeah. But I really, my take on this whole thing is that, Paul, God bless you for living in New York. I mean, unless the subway is going to have a police officer on every car making sure that individuals are safe, the fact that there's somebody who's put somebody in a chokehold, he didn't shoot the guy to death. I don't know if he really intended to kill the guy. He was just intending to stop him from harassing, threatening, and hurting anybody else there. Oh, thank you. Thank you, Andrew. But yeah, no, I mean, that to me, I'm just like, how are we talking about wanting to, what does he need to be punished for?
Yeah.
That's how I feel.
Well, Paul, how does this, so, I mean, I think there's a pretty good argument for appeal, but, what is your thought? I mean, what was this judge thinking? Because what happened, I think, was clearly so outside of the bounds, out of bounds, so to speak. What do you think was really going on here? You're on the ground up there.
Yeah. So the judge, first they come back deadlocked. The judge sends them back with the Allen charge and says, essentially what he's telling you with the Allen charge is go back and try again, right? And you got to hit that very gently because it can't be coercive. All right. In doing that, however, he refers to the jury charge and he says that language that, Phil, you were just alluding to, which is that you can't go on to the lower count unless you find him not guilty on the top charge. So that kind of locks him into that position. Jury comes back a couple hours later and says, we're still hopelessly deadlocked. Now, remember something, in and around all of this, actually just before, one of the things they asked for was a readback of the language relative to the reasonable person standard. Reasonable person standard is embedded in the affirmative defense in New York. It's an affirmative of justification. That affirmative defense has to be overcome beyond a reasonable doubt by the prosecution. Let's all remember, burden of proof is on the prosecution. So they put the reasonable person metric in play, and that just is, what would a reasonable person do under those circumstances? It's a little more complicated for the audience. There are subjective interpretations, objective interpretations. The New York law is not wonderfully written, but essentially that's it. Objectively, would a reasonable person believe that Daniel Penny's actions were justified in light of the threat that was posed? That becomes very fact specific. And we should look at a couple of facts real quickly. Number one, the people that Daniel Penny stepped up to protect were themselves people of color. If you look at the body cam footage of the cops that show up and do the interviews, everybody's either black or Hispanic. Most of them are women. And the testimony from the women is really jarring. There's a woman who's there with her baby that reportedly Neely was bent over and moving towards as he was yelling when Daniel Penny decided to act. There were other women there. There's another woman that says she was so frightened she literally almost passed out. She says it was the most frightening thing that ever occurred to her. Consider, Daniel Penny is the toughest target on that train. He's the guy least likely to be hurt. He could have just sat there and stared at his shoes and said, this guy wants to attack a woman or an Hispanic woman with a baby. If he's a white supremacist, right, he's going to say, what do I care? Instead, he jumped up. He held on to him. In the summation for the prosecution, they said he hung on 51 seconds too long. Penny's own statements were that he was still struggling. I was holding him until the doors opened or the cops arrived or until he stopped struggling, because I knew he was going to get up and keep doing it because he was so vehement. He was really screaming. And anybody who's ever been in a subway car between stops knows how tense that can be. You really feel trapped. It's very hard to consider that unless you've ever done it and said to yourself, wow, everybody in New York's had this experience, by the way. This one was particularly extreme. Everybody in New York's been on a subway, crazy gets on and starts yelling and screaming. So I'm not making light of his death by any means. There's a whole other argument here to be had about how completely non-functional New York City's homeless services and mental health facilities are. It's a boondoggle. It is a power structure that just resists any reform. It's completely non-effective. And yet nothing ever changes, including subsequent to all of this. So all of that marbled together, the top charge looks like it's out the window, and we are certainly in mistrial territory. And Phil, I just want to mention that the judge was himself not very sure. When this all occurred, the judge literally said, I got to go back and check the case law on this. The judge said that. Then and there's a little bit of inside baseball. Then the DA who's prosecuting the case, the ADA that's in the room, gets frantic. She's working her phone. She's talking to the other lawyers that are on her team that are sitting in the first row of the audience. She steps out. My understanding is she calls the appeals bureau, all right, which is who they always default to. In comes the cavalry, an appeals attorney. He comes in. He makes the argument that we'll just drop that top case, which you call an underhanded stunt, which I agree. And he just said, we'll just drop, that top charge. Let's knock that out, pretend it wasn't there so we can start with a clean slate on the lower charge. The judge goes for it. He allows it. I am sure, and of course, then the defense objected to preserve for appeal, etc. I am sure over this weekend, everybody involved, the prosecutors, the defense, even the judge and his clerk, they're scouring the case law. And they want to see, is this thing going to hold up? Because this was all done in a very focused period of like an hour and a half, where all this came to a head. And of course, on a Friday, and I was on TV earlier that day doing the kind of hit you did, Phil. They were asking me about the case. And I said, these things always happen on Friday. And so I wouldn't be surprised if we see the whole drama unfold today.
Well, you and I were on together, I think, at the same time when it came out that this was a hung, and they didn't know what to do, right?
That's right.
And so look, I don't, at the risk of covering your faces up for a moment, let me just show this image here. This is from Inner City Press and on X, and it's the ADA says, listen to this, guys. Don't tell them, meaning the jury, it's an acquittal on count one, because it is effectively an acquittal. I mean, it's over. You can't bring that back now that it's dismissed. So they don't want to tell the jury the effect of what's happened here. But when they dismissed it, it was effectively an acquittal on count one. Only tell them that it's dismissed. And so Penny's lawyer says, this has never been done before. It would encourage prosecutors to overcharge in the grand jury with the option of withdrawing a charge if the jury's hung, and it would be basically under coercion. And then Judge Wiley says, listen to this, guys. This is what really, really gets me. Quote, I'll take a chance and grant the people's application. Right. I'm going to let them go to return and consider count two on Monday. Bring them back in. He literally says, I'm going to take a chance. So the judge is deciding that despite the existence of all this contrary case law, he's going to take a chance. I mean, what kind of, look, we talk about here inside the law, guilt or innocence is really, not sort of the point when we talk about this in the academic context. It's fairness. We want the trials to be fair. We want judges and juries and prosecutors and everybody to follow the law. But when judges don't follow the law, you wind up with this kind of mess. And look, we're not in the clear yet, because we have people on the streets now. The jury is spending the weekend at home. They know they've got to come back on Monday, right? And so check this out. This is what's happening now.
I'm the co-founder of Black Lives Matter Greater New York. I stand here heartbroken because I have to hug a father who knows that the murderer of his son will most likely go free, who has to look in the face of a jury that no matter the facts, no matter the expert witnesses, no matter the people yelling on that train that day to let Jordan go, you will kill him. They will not find a white man guilty of killing a black man in modern day America. This is no different than Jim Crow. This looks like a picture out of the picture book when you look at that anonymous jury. We have baby boomers who were there doing Jim Crow on this jury. We have young people who are looking at Daniel Penny as a hero. And what America is a hero, a killer. He didn't give a crap about Jordan. The medical examiner said Jordan turned purple. Yes, black people can turn purple when they are denied oxygen. Every lab report showed he died of asphyxiation. And that doesn't matter because they want to spare a white man the penalty of his crimes. America has not changed, and I hate to say it, it may never change. And people who keep asking, are we going to riot? Are we going to protest? Is that what's needed? Do glass have to break? Do cars have to burn for a black man to get justice in America? We can't show up with peace. We can't show up with facts. We can't show up with evidence and witness after witness. You give us nothing. And then you...
So there you have it. We rearranged ourselves. That's the commotion now. I guess outside the courthouse, So if you're on the jury and you hear these threats that there's going to be glass breaking and violence, and depending on your verdict, doesn't that affect you if you're on the jury, Rachel?
I mean, I hope that it wouldn't, because unlike what she's suggesting, I mean, the jury is considering facts and they're considering circumstances, and she doesn't seem like she really is. So obviously that's an intimidation tactic. In this case, I don't think I understand that a black man was the one that lost his life and that a white man is accused of causing it. However, I mean, some things just really aren't about race. When you're on a subway and somebody is threatening several female passengers, I mean, I don't know how she would have handled herself, that woman who was screaming at the top of her lungs, how she would have handled herself or expected somebody else on the train to protect her under those exact same circumstances. Race has nothing to do with being threatened and being harassed. And she should, unless she was sitting if she was sitting there the entire trial and knows the facts, maybe she should say something, but it sounds like she just likes to get the microphone and turn it into something that it's not. So,
well, Paul, you and I have talked about this. There's some lawyers on that jury, at least a couple, maybe more. Do you think, Paul, that the lawyers that are on this jury, do you think they might know that what the judge did was somehow improper? And the second question for you is, if you're, let's say you're defending this case, do you go in Monday morning in light of the video that we just saw and renew any objections or make additional motions for a mistrial so that you don't risk a jury convicting somebody based on the wrong reasons?
Right. So, I mean, well, first of all, that has happened all along during this trial, and these protests outside have been brought into play in the courtroom. The judge has, for the most part, been indifferent to the defenses and treaties to try to make sure this doesn't come into the courtroom, because there's some indicia that one of the witnesses was, in fact, intimidated and made statements about that. And in fact, one of these protesters at one point got into the courtroom and was sitting there very visibly. Look, would Daniel Penny have not acted if Jordan Neely had been white and did all the same stuff? Does anybody really think that if a white guy got on the train, started screaming in the same way, said, I'm going to kill somebody today, and I don't care if I go to jail or die, takes off his jacket, throws it down, bends at the knees, and begins to move towards a mother and child? If he were white, does anybody think Penny then says, well, go ahead, I'm not going to do anything about that? Of course not. His Marine instincts and his protective instincts kicked in, and he did what he did, irrespective of Jordan Neely's race. And you have to say to yourself, unavoidably, where were all of these people when Jordan Neely and so many like him are homeless, on the streets, getting in trouble? The family is now suing Daniel Penny. Where was this family when Jordan Neely was living hand to mouth in the subway cars and on the street? Remember, Neely was out. He's got multiple priors. He was out on a warrant for randomly punching a woman in her late 60s in the face not long before that. And he was under what is supposed to be the cure-all, according to the homeless advocates in New York City, which was mandatory psychiatric treatment. There's mandatory and there's mandatory. He just walked away from it and wasn't attending it. That is what passes for mandatory in New York City. So, yeah, I believe, Phil, renew that motion for a mistrial. I also suspect they're going to show up on Monday loaded up with other motions relative to case law research that they did over the weekend. I think we're going to have an eventful day tomorrow. And I'm sorry, I forget your first question.
Oh, well, no, it was, maybe I forgot it too. I think you probably answered it. That was really good stuff. I mean, it was whether or not you think the lawyers on this jury might understand the import of what the judge did and that it was wrong.
I think, yeah, you know what? I'm glad you reminded me, because I want to speak to that. I think the lawyers in this case are the ones, we don't know if they're, I mean, for all we know, they are contract lawyers or something, but I think that the lawyers intuitively from law school and dealing with it understand the metrics of the justification defense. And I think that's why this reasonable person standard has been teased out. And I think that's going to stay, which is why if the case does go forward, the trial, I think we're likely to see the jury hang even on the lower charge.
Well, I think that's where I am too. And Rachel, when I finish, I want to get your thought on that too, because I think that there are people on that jury who ride the subway in Manhattan and they see the same things like Paul, like you were describing. They know what it's like in there. And so there's probably some of them that say, look, I mean, I get scared too. I get it. I can relate to someone being in fear for their lives. And you probably have some hardcore holdouts on the other side too, that, just want to convict no matter what. We don't really know what the breakdown is. It could be 11-1 or it could be 6-6. We just don't know. But I'm with you. I think that if this jury were inclined to convict him, they would have done so, even on count one. That's and right. I think that, I think now the prosecution is, Yeah, I'm glad it happened this way, but they made a mistake. They can never bring back that more serious charge ever again. So that's over with, and I think they're going to probably, at best, they can hope for a hung jury on this, and then they have to ask the question: if are they ever going to try it again? Rachel, what do you think is going to happen this week with this jury?
I also think they're going to hang. I think that there's enough people that's on the jury that think that it's justified and are not going to budge. I don't care if it's. I mean, because again, we didn't figure out on the first count that they hung on whether the basis was justification. I would imagine that is. I mean, when you think about the case, and that's what we've been talking about, that would probably be what we would be arguing in the jury room and during deliberations. So. He's not going to be convicted whether they try him again. I mean, I think that'd kind of be a joke because, again, what's the point? This guy has no criminal history. He wasn't intending to kill anybody. Marcus agrees with me. At this point, I just think they need to move on. And, the outrage, I have no problem with people who believe, I mean, there is racism in America. That is not, that I do not deny that. But not every case and not every situation requires this level of protesting. I mean, because again, she's talking about facts, and it's like, well, the fact is that this guy has harassed and assaulted people several times before, and she's just ignoring all those facts to make it about race. This is a case that, I mean, should cause the government to care a little bit more about how we handle severely mentally ill people living in our cities and using our public transportation, because it's not fair to the other people who are living there to have to make these kind of choices in the moment. It makes complete sense to me that the guy would hold him in a headlock until they got to the next stop, whether that's 51 seconds too long. I mean, I'm sure there's some stops that are shorter and longer. This is not a criminal case. It's an unfortunate incident, but it was a recipe for disaster given the guy's lifestyle and given his actions. And so I feel terrible for him. I would say I feel terrible for his family, but I feel like his family, instead of blaming everybody else, should be looking within themselves as to how they failed their son. They failed their child.
Well, Paul, in just a minute, I'm going to get you to tell us about the ops desk that we can see the signage on your microphone. But before we do that, I want Trenton ask, if they hang up, I guess on count 2, can the state try him again on that charge? The answer is yes. I think count 1 is over and done with, but let me I say yes with an asterisk beside it. If it turns out that the judge, if it's adjudicated by an appeals court that what the judge has done is wrong, that will probably be the end of it. But theoretically, all things being equal in a hung jury situation, yes, they can come back. But this may be the exception to that rule, Paul. What do you and the ops desk think about that?
I think you're right, and I'm going to go out on a limb here and say that if Alvin Bragg has any daylight to retry this case, he'll do it. And here's why. First of all, he swung and missed on the Trump case, right? That was a complete debacle. Every lawyer I knew found it to be a complete self-licking ice cream cone, as the self goes. It was all interdependent. Each count dependent on the other count, et cetera. That there were massive amounts of appeal issues and so on and so forth. So that is generally perceived as a loss, not only nationwide, but even here within the Manhattan DA's office. Still have a lot of contacts there. They were embarrassed by that case. And by the way, they were not Trump voters, but they hated that case. They knew it was what it was. Now you got another high profile case. He's already so far 0 for 1, he's got the safe harbor, he hopes, of the lower charge. Let's remember something else. The cops did not arrest Daniel Penny after the incident. They did the investigation at the scene. They bring him back. They interview him. Penny says all the right things, which is why he didn't take the stand, by the way. And so they said, you know what, this looks justified. Kick it over to the DA's office for presentation to the grand jury if he wants to go that far. But at this level, we're not making that arrest. We don't feel we have probable cause. 99 times out of 100, what happens then, the DA looks at it, either DPs it, declines prosecution, or gathers the facts, brings it into the grand jury, and then operates off of an indictment that gives you top cover. Hey, it wasn't me. The grand jury indicted. The people of New York spoke. We're going to go forward on this case. What happens? In the 10 days between the incident and when they ultimately arrest him, the protests begin. And they weren't really that large, but they were vocal. And this city loves to cover this stuff. So you got these kids jumping onto subway tracks, etc., holding up subways and protesting in the streets. City Hall buckled, and they said, "Go arrest Penny." And it was City Hall, not Bragg, because Bragg doesn't give orders to the NYPD, and it was the NYPD who was told, "Go out and make that arrest." That happens to happen at the mayor level. So
Yeah, the
my
mayor's
point
now come out and said, anyway, I didn't mean to cut you off. Please continue. But the mayor has come out now when it seems politically convenient and said that Penny was justified. But I didn't mean to cut you off.
Yeah, he's because he's hoping for a pardon from Donald Trump,
Yeah,
and he's
he's got
moving
his
to the
own
right.
problems.
Right. So my point is this, just to sum up, is that the Bragg has dug himself in pretty deep here. I don't think he's going to let it go. He's in sympathy with these protesters. All of this tracks to his agenda. He needs a win. I think that he won't give up on this thing, just like he was willing to buck the currents blowing through the city at the time, because everybody saw this case for what it was. He went forward on it. This is who he is. He wants to be reelected. He knows Manhattan. And you know what? The chances are he will be reelected. And that's how crazy things are here. So I'm going to predict that, as we said, jury hangs. He's going to retry the lower charge at the very least. He's going to go forward on it, unless, of course, it gets knocked out at the appeals level, which, by the way, would be doing him a favor.
Yeah. Hey, Rachel, is your mom?
Yeah, I was going to tell her to come over, and then we're going to go eat some dinner because I'm hungry. But okay, wait. So you guys
Rachel is eating for
closer,
maybe 3.
closer.
I don't know.
Hi.
I'm humongous. Paul, did you know I'm 31 weeks pregnant? Here we go.
I know now.
Hi, Rachel's mom. Is your mom going to be there with you now for the duration?
Well, so yeah, she's not going to be with me for the duration, but she's coming back soon. So I haven't. My other sister has children, so she's kind of between there and here. But her and my partner just
We just built a bassinet while you guys were.
Oh, you built the bassinet. Good for you. All right. Well, Grandma, is this your first
I'll assume
grandchild?
that's for the baby.
This is my third grandchild.
Nice.
And it'll be the last if I'm done. Yeah. One and done for me, Paul.
Okay. Well, Rachel, when you're on maternity leave, then your mom can fill in for you here inside the law. Because she would do great. And Paul, take a minute. Tell us about the ops desk and where folks can find you there. It's a great podcast, by the way.
I appreciate it. Yeah. So, we do some writing, we do some podcasting. You can just find us at opsdesk.org and just click at the top, and you'll see the button for the newsletter and the Substack, etc. So if you go to opsdesk.org, you click at the top, you'll see everything that's going on. It's me, it's some lawyers, it's some cops I know. And we publish as we can, dealing with the kind of issues, Phil, that you deal with so well here as well.
And you guys do it well. I get those Substacks, and I get what you send out, and I listen to the podcast, and you've had me on, and I look forward to coming back on that podcast.
Oh, we got to do it. Yes, please.
Maybe we'll get Rachel on there too one day. But check out the Ops Desk if you haven't done it. It's a great podcast. Look, guys, thanks so much for joining us. We're going to go ahead and have to call it a day. Big round of applause for Paul Mauro. We'll let Paul get back to a lot going on up there in Manhattan, buddy. So I'm going to let you go back to it.
Don't remind me. All right, guys, I really appreciate it. And hello to everybody in Atlanta, and hope to see you soon.
Yes,
See
sir,
you
buddy.
soon.
All right,
sound like Paul.
Rachel,
I wish I was from New York.
and Grandma, thank you guys both. We are so glad that you've got the grandbaby on the way. And have you got a name picked out, Rachel?
Yes, and I don't nothing's a secret in my life. His name is going to be Clyde.
I knew the answer because I saw you posting about it on X or something. But yeah, so
proudly.
All right. All right. Well, we can't wait to hear and learn all about Clyde in a few months. But anyway, Nice to see you. Thank you both
Thank you, Phil.
for sharing thank you for sharing your daughter. And Rachel, thank you for sharing your afternoon with us here inside the law. Big round of applause for Rachel and family.
Thanks, Phil. See you guys soon.
All right. And so we're going to have to leave it there. But look, I mean, the YSL trial the first one is over. And we've got another one coming up. And of course, we've got the Penny case. We've got all the other things. We've got this ongoing manhunt that we're going to be following here inside the law. We may have some special episodes coming up this week on that as it develops. I'm trying to put that together now. And, looking forward on the horizon, there's other great legal cases out there as well. But I don't know that there's going to be anything that really is all that enthralling like this first YSL 1.0 was, but we'll see how it plays out. I wouldn't be doing my job here if I didn't mention that we are still watching and waiting with regard to the Fulton County Trump RICO case. That is still before the Court of Appeals. And the Court of Appeals, as you know, was asked to toss Willis off of that case. The oral argument was supposed to be this past week on December 5th. It was abruptly canceled in a one-word order. They said, we're going to cancel oral argument. Those of us watching it think that means that the various defendants would be likely to win that, meaning that Willis would be removed from the case, and there really would not be any realistic way to get another prosecutor on the case. But now we have President-elect Trump, through his attorneys, have asked the Court of Appeals to go in another direction. They've now asked the Court of Appeals to effectively dismiss the case because of the results of the election. The theory, generally speaking, broadly speaking, is that we can't have a sitting president of the United States under indictment in a state court under the supremacy clause. Now, if you carry that out to its logical extension, what could happen if let's say that comes to pass? Would it be dismissed with prejudice or without? Meaning, would it be something that's over and can never be brought back? That would be a dismissal with prejudice. But I think if they follow this legal argument and grant the dismissal on that basis, I suspect it would be a dismissal without prejudice, meaning that Fani Willis would be free to bring it back in 4 years. We can have another stream. It's another long discussion about which would be the right way to go. I'm talking with folks, maybe hoping to get Ashley Merchant here inside the law in the very near future to sort of explore some of these ideas with her and some others. But those are some of the interesting things that are sort of on my radar. Maybe they are on yours as well. But if nothing else, guys, with regard to this first YSL case, hopefully we will never see this in court again.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break. Hang in there.
When this is what passes for a state's star witness in a major racketeering case, at least in the beginning of the case, then the justice system has big, big problems, and we're just getting started. Please subscribe to the channel. We tell all your friends, your family, your coworkers, your postal carrier, everybody you know, if they want to learn something about the real justice system, tell them about Inside the Law and have them subscribe here. We're going to leave it there for now. Wish everyone happy rest of your weekend. Merry Christmas, Happy Hanukkah, Happy Holidays, all of the above, whatever may apply to you. Look forward to seeing you back here next time Inside the Law.